All right, so here we are with Module 7 talking about the legal system. And thought there might be, I thought there'd be a point when it finally got rid of the stupid sidebar. All right, so I think we all know about this from police procedurals on TV. But anyway, I did work in a lawsuit settlement administration firm for years, so I may overestimate the extent to which this stuff is common knowledge. So a jury is a group of citizens chosen to decide if someone is guilty or innocent. The plaintiff is the person who is complaining about something, and the defendant is the person defending themselves. And the most common situation is a financial lawsuit here. That's civil law, although computer forensics is important in criminal law too. So common law is based on case law and precedent, and this is what you hear the most about in the news because decisions made in one case set a precedent and affect future cases. And in complicated situations like computer crimes, it is very often the case that the law does not really make it clear at all whether something is illegal, and it relies greatly on precedent, the decisions made in previous similar cases. All right, so civil law is the law that does not involve people going to prison generally, but involves just money, which is the most common thing, where you sue somebody for some kind of harm they have done you, and what you're hoping to get out of them is money. All right, there's constitutional law, statutory law, and regulatory law. Constitutional law is federal law tied to the U.S. Constitution. Statutory law is written at the state level or other local levels. And regulatory law is government authoritative agencies, and this, incidentally, is the main target of the current MAGA Republicans. They want to end the so-called deep state, and what they want to do, and they're having a lot of luck doing, is ending regulatory law. For example, you have an environmental protection agency, which is allowed to make decisions that you're not allowed to pollute in a certain way, and the Supreme Court has gone with them and saying, you can't do that. You have to pass a special law for every action. You can't have a regulatory agency that regulates something. And we'll see how that goes. But there's currently quite a push to try to limit this regulatory law. Anyway, so then there's the court system. You've got the Supreme Court on top of everything. And unfortunately, there is no higher appeal to anything than the Supreme Court. And there are no ethics rules that apply to the Supreme Court justices, which is being spectacularly demonstrated as the bribery and corruption of the Supreme Court is being made clear by ProPublica and other news agencies. And there doesn't seem to be much of anything we can do about it. However, below them, there's a structure. Circuit courts of appeals and federal courts of appeals, and below that, the lesser courts. And so if you make a decision at one of these courts you don't like, you can try to appeal to higher courts until you get to the Supreme Court. But after that, there's no higher place to go. All right, so those are the appeals courts and the federal courts and the Supreme Court. And there are 13 circuit courts of appeals, and unfortunately, as again has been made incredibly clear in the last few years, they are very biased and very different. There's one judge in Texas that will always rule with the MAGA Republicans on anything, so they carefully determine everything in that circuit, and there are other ones that are more liberal, and you get completely different decisions based on these different justices. All right, so there's a lot of these different courts, and there's things like family court and juvenile court and small claims and all these different courts you can go to. And this is why many people have criticized American society as being lawsuit crazy. There's a ton of legal obstacles all the time, a ton of lawsuits going on all the time, but that's the way it is. And of course, it makes employment for all of people who want to be expert witnesses. You learn a skill. So you have jury selection. You start with a large pool of people who are compelled to come. I've done it, of course. Most Americans have done it. They bring in a ton of people, they pick some of you, you have a bunch of you sitting in a room, and they try to pick a jury from among you, which means that they start with a lot of people, and then each side gets a chance to ask questions, and the judge can ask questions, and they can decide to exclude you for a variety of reasons, usually because you have some kind of bias in the case or some kind of connection with the case. Then they give you an oath and instructions. There are opening statements where both sides state how they're going to prove what they claim. Then you have witnesses and evidence, closing arguments, jury instructions. Then the jury goes off into a private place to deliberate, which can take from hours to days. And then you have a verdict. And then after the jury makes a verdict, then the judge declares sentencing. So the right to trial by jury is outlined in the Sixth Amendment. So this is the idea that instead of having a corrupt king who can just decide he doesn't like you, you have to have citizens that are your peers that examine the evidence and decide whether you've really done something wrong. And that's the plan. And in practice, I must say, it seemed to work very well. And I've heard this. Most people, even though they may be pretty annoying and argumentative, when they serve on a jury, most people take it seriously and work hard to be fair. That certainly seems to be true in my experience. So voir dire is this process of selecting the jury. It's Latin, I think, for to see and to say. I'm not quite sure, but anyway, it's where you ask questions to see if you are somehow going to be biased in the case and should therefore be excluded from the jury. And you can get contempt of court if you do something outrageous that offends the judge, like you won't shut up when it's your turn, you keep raising irrelevant things, you keep saying things you're not supposed to say, and so on. It can be a variety of things, but basically if you disrespect the judge and the court and disrupt the proceedings, they can declare contempt of court and they can jail you for contempt of court. And this is unfortunately what happens to journalists who have a confidential source. This is, if you are a priest and someone tells you something in the confessional, you are allowed to not divulge that in court. And if you are married to somebody, your spouse can tell you something and you are allowed to not reveal that in court. But journalists do not enjoy this protection. So if you have a confidential source that tells you something, you can go to court and the judge can demand that you tell them who it is, and if you refuse, you can go to prison. And journalists have gone to prison for a year or more for contempt of court for not exposing their sources. It is one of the riskier parts of being a journalist in America. All right, so the open statements, we've talked about this stuff. And then there's direct examination, where you question a witness, and there's cross-examination when the other side gets to ask the same witness more questions. All right, then you get a verdict. Okay, I mentioned this before. Criminal trials are initiated by the government on behalf of the people. For example, if somebody gets murdered, there may be nobody around who is worried about that. I mean, maybe no family relatives or anything around, so there's nobody to actually personally initiate a lawsuit, a court proceeding, but the state will do that. They will punish somebody for committing the murder, even if there is no surviving person complaining about it. This is not true of financial crimes. If somebody commits a financial crime against you, it'll wait for somebody to complain and be the plaintiff, and they can choose not to press charges. But in criminal charges, it's initiated by the government on behalf of the people. A felony is the serious crime with a year or more in prison. A misdemeanor is a less serious crime. A deposition is a type of evidence that is taken outside court. They record, you meet with I've done this, you meet with a lawyer outside court, they swear you in, you make statements, you are liable for these statements, you're not allowed to lie, but it is just a recording that is taken to court. Bill Gates, in the famous lawsuit against Microsoft for antitrust violations brought about by Windows 98's use of the internet, made a deposition where he made many obviously false statements, and that weighed heavily against him in court. Anyway, so a civil trial is disputes over money, and so you go. All right. Then there's constitutional law, which is widely misunderstood in the modern world. Constitutional law is the amendments which limit what the federal government can do. And one huge area of enormous misinterpretation these days is a huge amount of angry right-wingers claiming that their First Amendment rights are being violated when Twitter cancels their account. And that is absolutely not true. The First Amendment applies only to the U.S. federal government. The government cannot restrict your speech. Individual companies can restrict your speech. They can throw you off their platform. They can have any rules they want, just like an individual business can refuse to serve you, like a restaurant. It is not, the First Amendment does not apply to that. It applies to the government. And the point here is the government can't restrict speech or establish a state religion. And the Fourth Amendment is extremely relevant to computer forensics. The Fourth Amendment says that the government cannot search your stuff without probable cause. They need to have probable cause and get a search warrant that specifies what they're looking at. They cannot just arbitrarily go in your house and start looking for stuff for evidence of crime. All right. Now, there are exclusions. There are things you can seize without a warrant. For example, in an emergency, when someone's life is at stake, that's exigent circumstances. Then there's an issue called fruit of the poisonous tree. If you originally acquire evidence illegally, and then that evidence leads you to another source of evidence, you're not allowed to include that either in court because it's the fruit of the poisonous tree. All right, and motion in limine is the term for a request to suppress evidence. which is a big issue in almost every trial I've heard of. They will argue that for some reason certain evidence should not be included, and this often will have a great effect on the outcome of the case. And this is why the whole thing is a little strange and theatrical, because the jury does not really get to know all the evidence. The jury only gets to see the admissible evidence, so it is commonly the case that press reports report things that seem really important, like this person committed a similar crime previously, and yet the jury is not allowed to hear that, which is why they say the jury is not allowed to watch the news or read newspapers about the case or anything, because they're not supposed to have all the evidence. They're supposed to have only the permissible evidence. All right. So search warrants are the most important part for us. Law enforcement must obtain a search warrant before they can go somewhere and seize the computers and cell phones and other devices. And the warrant does not give them carte blanche to take anything they want. The warrant will specify you're only allowed to take these things from this location. This has been a big problem for taking down botnets. Botnets are networks of infected computers under control of a master server, and Microsoft started trying to take them down legally. And you can take them down. For example, botnets often infect machines through vulnerabilities, and you can find the vulnerability, and you could use that vulnerability to clean the botnet malware off a machine. But how would you get the legal authority to do that? You're committing a crime just like the other person. So Microsoft has sort of pioneered getting legal permission to execute code on machines over the internet when you don't even know where they are, which is a very problematic legal situation because, for example, if those machines are in another country, how could any court possibly have the authority, the jurisdiction to allow you to do that? But Microsoft has done this several times, where you take over the master control center and you take over a botnet of machines. So an interesting, complicated legal case. Like I say, there are warrantless searches, especially since the Patriot Act in response to 9/11. Certain conditions, for example, you can consent to a search. This is often the case. If you agree to a search, that's, of course, the end of your rights to resist a search. And sometimes they use knock and talk to enter a place. And the plain view doctrine means they can seize evidence that can clearly be seen from a public area. All right. All right. Now, the one issue worth mentioning is standing. This is a huge issue in the latest Supreme Court rulings that came down last week. You only have standing if you are a party that stands to have some kind of injury. And in particular, the case brought against gay rights, where a website designer, recently decided that they were allowed to refuse to make a website for a gay couple, although it turned out that the person making the lawsuit was not, in fact, in the business of making websites, and there was no gay couple that had, in fact, ever asked them to do that. And that normally is a clear violation of standing. You're not allowed to sue for a theoretical thing that doesn't exist. You have to have a real person who has a real injury that they're complaining about. And yet the Supreme Court has completely ignored that and begun to make rulings on entirely falsified or hypothetical situations, which arguably, and in the dissenting opinion is very clear, completely violates the Constitution. That is what Congress does. Congress can pass a law without any specific person complaining, but the courts are not allowed to do that. Courts are only supposed to rule on specific cases where there is a plaintiff and a defendant. There's a real issue to be resolved, and they have been violating that. And as I said, there seems to be absolutely nothing we can do about it because there is nowhere to appeal above the Supreme Court. Anyway, so digital surveillance is a big issue. We have cameras recording us everywhere. There are microphones in some places, although it's very difficult to legally put up a microphone. Spoken speech is much more protected legally than visual images in America, although not in Britain. Britain is the most heavily surveilled society in the world. They have cameras on almost every corner and microphones on almost every corner recording what people say. Stingrays are the main thing in America. A stingray is an electronic device with an antenna, a radio transmitter that you put in a car and you drive near an area, and it puts out a cell phone signal claiming to be a cell phone tower. And all the cell phones for some radius around a few blocks will now connect through that cell phone tower, and they can downgrade the encryption to an older version so they can decrypt it, and they can collect all the information sent through the cell phone network in that area. Now, this is very problematical because they cannot get a search warrant for everybody within a few blocks. They probably have a search warrant for one person whose house is there, but the Stingray collects all the data from everybody around there. And this is another difficult issue in American law enforcement. The NSA sweeps up incredible amounts of data from the internet, and then they claim they will only look at the stuff they're authorized to look at, but there's no way to verify that they've restricted themselves in that way. And in fact, it is abundantly clear that they do not. And you even have the bizarre situation where the NSA will scrape data from the internet, find out information about American citizens, which they are not allowed to use. They will hand it to the FBI for punishment of those people in America, and the FBI will then lie in court and do something called parallel reconstruction, where they make up a fictitious story about an informant that gave them that data, so they do not have to reveal they got it from an illegal acquisition by the NSA, and all of this appears to have held up in court. So it's very disturbing how many of these legal protections seem to be fictions in practice. Yeah?
Is it legal to own a Stingray?
That's a very interesting question. Is it legal to own a Stingray? I think it is. I wanted to build one here. You can own one, but you can't use it to intercept other people's calls. So in fact, I had a plan a couple of years ago to build one and put it in this room, because this room is pretty electrically isolated. And we could catch local phone calls from this room, but if you catch phone calls from the people outside, then you're violating wiretap laws. It is, by the way, extremely technically easy to do, but it's a huge crime. A very good question. Anyway, so then there's GPS devices. Oh, by the way, as mentioned up here, if you do pick up the telephone calls, one thing you often get is the pen register, and the pen register you don't need a search warrant for. The pen register just records what phone number connected to what other phone number and for how long. And so it is the information they need to make your phone bill. They do not hear the sound of your call, but they do know who called who. And by the way, this is often all you want, because all you do is you have a criminal gang, you want to know who's in the gang, you arrest one guy, and then you record who do they call right away to warn them. That tells you who the rest of the gang is. You can get a lot of useful evidence from a pen register, and you don't need a search warrant for that. All right, then there's GPS. We have GPS tracking on almost every car, and the law enforcement will often attach a GPS recorder to your car, and in many jurisdictions they've been doing that without a search warrant, and I've heard arguments about this greatly over the last few years, and I don't think it's resolved yet, whether they need a search warrant to put a GPS tracker on your car. The law enforcement argument has been, we could just as well have sent a police car to follow you around, and that's in plain view and it would have been okay, so how is the GPS tracker any different? And people argue. Anyway, certainly your GPS trackers do record everywhere you go, and there's a ton of useful data on them, so it's a valuable object from which to get data. All right, and then there's the Fifth Amendment, which says that you do not have to incriminate yourself. If law enforcement asks you questions, you can refuse to answer. You have the right to remain silent. All right. However, there are ways around it, and this is a big issue in Trump's many law cases, because if what the grand jury can do is they can declare, okay, we are going to forgive you of all your crimes and not prosecute you, and therefore you are not in legal jeopardy, and now you do not have Fifth Amendment protection anymore. The Fifth Amendment only protects you from incriminating yourself. If they give you an exemption from prosecution, then you no longer can refuse to answer questions. And there's a lot of evidence that this is happening to Trump right now. The people that conspired with him to overthrow the last election are being given this protection, it appears, so that they must answer questions. See over here. Do you think we will utilize more CCTV in San Francisco with facial recognition? Well, that's a very interesting question. Now, there is a lot more cameras in San Francisco because of the guy that made Ripple. Ripple is one of the cryptocurrencies, and the guy that made it is a billionaire, a very rich guy in San Francisco, and he got tired of all the cars being broken into in his San Francisco neighborhood, so he contributed money to put a whole bunch more surveillance cameras all over the place. And there are a lot, and also the Ring doorbells are often connected to police. And so there's a whole lot of extra cameras all over the place recording people. However, facial recognition is a whole nother can of worms. Facial recognition, about 5 years ago, there was a huge push to put facial recognition everywhere, and then there was a huge pushback as it was discovered that facial recognition is in fact very unreliable. In particular, facial recognition is extremely inaccurate on black faces. So it turns out if you use it for law enforcement, it very often fingers the wrong person. And I remember there was a case where some black guy was arrested and he was totally the wrong guy, but facial recognition incorrectly identified him. And someone went and took, I think, the Supreme Court members and found that like 2/3 of them were identified as criminals by the facial recognition at that time. So everybody pulled back. Microsoft canceled their facial recognition products. All the reputable companies pretty much pulled back from it. And right now, facial recognition is pretty much not used anywhere in America because it's just so unreliable. It is, I think, heavily used in other countries. But right now, I think most of the major product manufacturers have decided it is too dangerous for them to distribute any product used for facial recognition for law enforcement. Although, I believe one of the airlines, Delta, is using it instead of your boarding pass. You don't have a boarding pass, they just use facial recognition when you board the plane. And the TSA is using it in the airports to try to scan people as they walk by and see if they're on the do not fly list. So there are some limited applications of it in America, and probably there will be more as the technology improves. And it's very heavily used in China, all over the place. Can a person refuse? Well, I think you might be able to refuse with the airline. They might choose to let you refuse. I don't know if they're under any legal obligation to give you that choice. It's relatively new. I've never had it happen, but I think we're going to have more of this going on and more arguments about it. Anyway, all right. And then there's the Sixth Amendment, where you get a speedy trial. Doesn't really affect us that much. The Wiretap Act does, though, quite a lot. I mentioned before, if you have a telephone call, the telephone company is required to let the law enforcement wiretap it. They can get a court order, and then they have a wiretap order, they can hear the phone call. But if it's a Skype call on the internet, there's typically no way for the government to hear that, because there is no corresponding such law for the internet, although the FBI has been trying to get it for decades. So telephone calls are much less protected from the government than internet traffic. And that's why there's a huge issue in the internet privacy community to push end-to-end encryption, which is now on WhatsApp and many other services. You can encrypt something on the internet so strongly that the government really can't get in, and that is legally and technically possible. I'm always creeped out about having to provide a fingerprint. Yeah. I see Akerin with good points. Yeah, you could argue that you don't want to have your face or your fingerprint scanned when you board an airplane. And I'm not sure whether they can compel you to do that. All right. Anyway, the Foreign Intelligence Surveillance Act is the really tough one by the Patriot Act, which says that they can send you a national security letter. I think it's the related one. And you have to hand over your data, and you have to not tell the person whose data was handed over about it. This is very controversial, very troubling, and I think it's still going on. I heard a lot more about it a few years ago. The Computer Fraud and Abuse Act is huge for computer pen testers and hackers. This is how most computer crime is prosecuted. This is where you cannot connect to a system and remove data that you are not authorized to know. And this is what everybody does when they hack into systems. All right, then there's Corporate Espionage Act and other things like computer trespass. All right, this is CALIA, that's the one I mentioned, Computer Communications Assistant for Law Enforcement. That's the one that forces all telephone companies to provide some way for a wiretap. And then, of course, the Patriot Act, which greatly increased law enforcement's ability to gather evidence on internet and electronic communication, because it was a response to the 9/11 terrorism, in the feeling that with more government surveillance, we could limit future terrorism. All right, and there's more here, but I think it gets sort of mind-boggling. Now, here's some stuff that's more interesting, relevant to computer forensics. The Fry test shows that expert opinion must be based on science that is demonstrable and not experimental. So things like astrology and lie detectors are not admissible in court. They are not considered to be based on science. And there's constant arguments about science. There was a big stir a couple of years ago as fiber matching was removed under this. Fiber matching was commonly used in police tests. They would find some fiber lying around a crime scene, and then they would match it to fibers from like clothing or a sofa in somebody's house. And they recently decided that, although it had been accepted for years, would no longer be accepted because it was considered too unreliable. And the Daubert test says you have to perform benchmark testing on your hardware and software tools, so you're supposed to do something to make sure that your computer forensic software is operating correctly. And there's rules of evidence explaining this. So expert witnesses are what forensic examiners typically are. You go to court, you have all this information demonstrating that you are an expert because you have formal training and you've given all these talks and written these books and such, and then you are allowed to state your opinion from analyzing the evidence. Really amazing cases of fiber hatching. Yeah, that's interesting. Yeah. Anyway, so China can get your picture from social media and track your location. Yes, I think they can. And people do it in America too. There's a tool law enforcement's been purchasing to do that, but it's highly controversial. And when it's found out that they use it, they tend to have to stop using it. There's a famous product that scraped all the images from Facebook and the internet to identify people from their faces. And that's highly controversial, but it does go on in America to some extent. Anyway, so testimony is normally hearsay if it's not something you saw directly, but computer testimony might all be hearsay. You look in like computer logs or in the registry and you find something, that is some other thing telling you about it, but an expert witness is allowed to bring in that kind of evidence. And that's the point here. The expert witness is allowed to determine things by examining machines after they've demonstrated for their qualifications that they can be regarded as an expert. Then they are allowed to examine technical objects and state opinions about what they prove. And that is evidence. But the evidence is weighted by the jury to what extent you have convinced the jury that you are really an expert in the area. All right. There's also the CCPA, which is a California imitation of GDPR in Europe. Europe has much stronger privacy protections than America, which has led to a ton of problems. But California now has relatively strong protections under the CCPA, which is limits what people can do with your personal information in California. I see some more comments here. If you have your picture in LinkedIn and work for a defense company and you travel outside the US, they can track you. That sounds right. I haven't heard a specific case of that happening, but that does sound correct. All right, and then the European Union, as I mentioned, is different, although very similar. The main one is data privacy. The GDPR gives you a lot more protection in Europe. You have the right to demand to see all the data companies are gathering about you. You have the right to demand for them to delete it. And what are most egregious for American companies, they cannot collect your data for one purpose and then reuse it for a different purpose, which is the entire business model of Google and Facebook and essentially all internet companies. They collect your data and then they resell it over and over and over to make their money. And you can't do that in Europe. All right. And then there's privacy legislation in Asia, not much in China. The government can pretty much do anything they want. And in India, I'm not quite sure what the rules are. They mentioned a little bit about it here. But anyway, that's all I wanted to say about that. And let's try a Kahoot on Lecture 7. Which should be here and here. All right, there it is. Question there, do I know about working for the government if you have multiple citizenships? And I do not. I bet it gets complicated. You definitely have to find somebody else to ask about that. I don't know. I'm sure it gets pretty complicated. I have heard that people that got appointed to federal positions had to abandon their other citizenships. So I think there are certain jobs for which you cannot be a dual citizen, but I don't know enough about it to have a very informed opinion. right. I guess we'll give it a shot. All right, so what do state legislatures make? Yeah, they make statutory law. All right. All right, so when you ask jurors questions to see if they're biased, what process is that? That's voir dire. All right, so what request is used to suppress evidence? That's the motion in limine, to say that for some reason this evidence is prejudicial and not informative or obtained illegally or otherwise cannot be included in the case. All right, so which device records the phone numbers of calls as you make them? The pen register does that. The Stingray does much more. Stingray actually intercepts the sound of the phone call, but the pen register just records the phone number and the time of the call. All right, so if a hacker intrudes onto a network, what law have they broken? That's the CFAA.